A very good day, Miss Nora. The purpose of our presentation today is to explain some key concepts of contract law. We will be covering offer, invitation to trade, preview of contract, intention to create legal relation, and acceptance in counter offer. Through this presentation, we aim to demonstrate a clear understanding how a valid contract is formed and how these principles operate in real situation.
Good morning. My name is Jing Ting. Today I will be presenting the issue 1 that related of offer and invitation to trade. And the case is about Cepat Sehat Sdn Bhd advertised its product Imuni page and promised to pay 10,000 to anyone who use it daily for 30 days and still develop a severe skin allergy. And the advertisement also stated that 100,000 was deposited with Jun Bank to show sincerity. And Ida bought the product and followed all the instructions. Despite this, she developed a serious allergic rash. When she claimed the reward, Cepat Sehat refused to pay, saying that the advertisement was only a promotional gimmick. And in this case, there are two parties involved, which is the offeror is Cepat Sehat Sdn Bhd and the offeree is Ida. And for this case, the main issue is whether the advertisement made by Cepat Sehat Sdn Bhd is a legally binding offer or merely an invitation to trade. If it is a valid offer, the further issue is whether a binding contract was formed between Cepat Sehat and Ida, which would entitle Ida to claim the 10,000 reward. Generally, advertisements are invitation to trade, not offer, and this principle was established in the case of Patrick and Crittenden. And in this case, the court held that advertisements and secure lists are invitation to trade, as there is a business sense in advertising, except for manufacturers. This means they merely invite customers to make an offer to purchase. However, an exception exists for unilateral contract, where an advertisement can amount to a binding offer if it is clear, definite, and show an intention to be bound. And this principle was established in Khalil and Carbolic Smoothball Company case, where the court held that an advertisement promising £100 to anyone who followed the instruction used the smoothball and still contract the influencer was a valid offer. And the company's act of depositing money in the bank was strong evidence of serious intention, not a mere invitations to trade. And under Section 8 of the Contract Act 1950, acceptance occurs when the conditions of a proposal are performed. And in unilateral contracts, there is no separate communications of acceptance is required. In this case, Cepat Sehat's advertisement stated that 10,000 will be paid to anyone who used the Imuni page daily for 30 days as directed and still develop a severe skin allergy. And the advertisement further stated that 100,000 had been deposited with the Jun Bank to prove sincerity. And this bank deposit shows a serious intention to be legally bound, similar to the facts in Khalil and Carbolic Smoothball Company case. Therefore, the advertisement is not merely promotional, but a valid unilateral offer. And Ida bought the Imuni page and fully complied with the conditions by using it as directed. Despite this, she developed a serious allergic rash within the stated period. And under Sections 8 of the Contract Act 1950, performance of the conditions amount to acceptance. Since Ida performed all the required conditions, she accepted the offer by her actions, and a binding contract was formed. Therefore, Cepat Sehat cannot refuse to pay, claiming it never intended to reward anyone. However, Cepat Sehat could argue that the advertisement was only a marketing strategy and not meant to create legal obligations. However, the law looks at the advertisement objectively, not at the company's internal intention. The bank deposit clearly shows legal intentions, therefore, Cepat Sehat's argument is weak. In conclusion, the advertisement by Cepat Sehat Sdn Bhd constitutes a valid offer, not an invitation to trade, and Ida accepted the offer through performance, forming a binding unilateral contract. Therefore, Ida was entitled to claim the 10,000 reward.
Good day to Ms. Nor Azwan. Now I'll be discussing about the second issue, which concerns the doctrine of purity of contract and consideration from a third party. This issue arises from an agreement made between two fathers, Rahman and Johan, regarding a wedding gift promised to their children Aida and Hafiz. Briefly, Rahman and his close friend Johan agreed that if their children Aida and Hafiz married each other, each father would give them Rm 50,000 to the couple as a wedding gift. The marriage did take place and Rahman fulfilled his promise. However, Johan passed away before making payment. Aida and Hafiz then attempt to claim the 50,000 from Johan's estate, but the executor refused, arguing that they were not parties to the contract. The contracting parties here are Rahman and Johan, while Aida and Hafiz are third parties and intended beneficiaries of the agreement. The legal issue is whether Aida and Hafiz can enforce the promise of Rm 50,000 against Johan's estate, even though they were not parties to the agreement between Rahman and Johan. I will now move on to the first relevant legal principle, which is doctrine of purity of contract. Under the doctrine of purity of contract, only parties to a contract or those privy to it can sue or be sued on that contract. A third party cannot enforce contractual rights even if the contract was made for their benefit or if they have performed an act connected to the agreement. This principle is clearly illustrated in the case of Tweedle and Atkinson, 1861. In Tweedle, two fathers agreed to pay money to the groom upon marriage. The groom later attempted to enforce the promise. However, the court held that the claim failed because the groom was not a party to the agreement and had provided no consideration. The legal principle established in the case is that no stranger to the consideration can take advantage of a contract. Apart from privity of contract, another relevant legal principle is the requirement of consideration. Contract law requires that consideration must move from the promisee but need not move to the promisor, which means a person who does not provide consideration cannot enforce the contract. This principle was reaffirmed in Dunlop Pneumatic Tyre Co. Ltd. and Selfridge & Co. Ltd. 1915, where the court held that only parties who have provided consideration may sue on a contract. Having explained the relevant legal principles, I will now apply the law to the facts of the case. The contract in this case was formed solely between Rahman and Johan. Aida and Hafiz were not parties to the agreement and did not provide any consideration to Johan. Although they were intended beneficiaries, this alone is insufficient under the doctrine of privity. Similar to Tweedle and Atkinson, Aida and Hafiz are third parties attempting to enforce a promise made by others. Therefore, they have no contractual right to claim the Rm 50,000 from Johan's estate. In conclusion, the doctrine of purity of contract applies, as Aida and Hafiz were not parties to the agreement and provided no consideration. They cannot enforce the promise. Accordingly, Johan's estate is not legally liable to pay the Rm 50,000. Thank you.
Good day, Ms. Nora. I'm Mugilin Sivan and I'll be explaining on issue 3. The issue concerning intention to create legal relation in a social and domestic agreement. In this scenario, Aida was struggling financially and accepted her mother's offer to leave her nurturing job and pursue law studies full-time. Her mother promised to provide a monthly allowance of 2,000 ringgit until Aida graduated. After 1 year, disagreement arose between them and her mother stopped paying, insists that family agreement are not contracts. The parties involved are the promisor, Aida's mother, and the promisee, Aida. The issues are whether the promise to pay 2,000 ringgit monthly created an intention to create a legal relation, and whether the agreement is a legally binding contract or mere family agreement. Moving on to the law that applicable to issue 3. Under the general rule for social and domestic agreements, agreements made within family relationship are presumed to not create a legal relation. This means even though there may be a clear promise, the law does not automatically treat it as legally enforceable. This presumption exists based on public policy consideration, as the code are generally reluctant to interfere in private family matters and domestic agreements. This principle was clearly explained in Chu Tiong Hin and others and Chu Hock Swee, where the code held that family agreement depend on filial duty and parental responsibility rather than legally enforceable through courts. Similarly, in Bafer and Bafer, the court held that agreements between family members who are living in amity, meaning on good terms, are not intended to create legally binding contract. The court emphasized such domestic agreement made in ordinary course of family life are not meant to give a rise to legal consequences. Moving on to parent and child financial agreement. The key authority here is Jonas and Perevathan, where a mother promised to financially support her daughter's legal education. Despite clear promise, the court held that the agreement was a family agreement and therefore there is not a legally enforceable contract. This case is important because it shows that even where a financial support is provided for education, the code will still presume that there is no intention to create legal relation in a parent and child relationship. However, there is an exception to this general rule. Intention to create legal relation may exist where parties are not living in amity or where the agreement is clearly reduced to writing. Applying the law to the fact, the agreement was made between a mother and a daughter, which is significant because it immediately placed the agreement within a domestic and family relationship rather than the commercial context. Because of the relationship, the law starts from the presumption that the agreement was not intended to create a legal relationship, unless there's a clear evidence to the contrary. Looking at the nature of this promise, the agreement to pay 2,000 ringgit was oral, informal, and not reduced into writing. These features are consistent with the family understanding based on trust rather than the contract intended to be enforced by the court. Importantly, at the time when the promise was made, the parties were living in amity, meaning they were on good terms. The agreement was therefore based on trust and goodwill, which further support the conclusion that the legal consequences are not contemplated when the promise was made. Continuing with the application, the purpose of the allowance was clearly support Aida's education. And this falls within what law recognizes as a normal parental responsibility. Parents are commonly provide financial support for their children's education, and such support is usually motivated by family's duty rather than an intention to create a legal relation. The facts of this case were closely similar to Jonas and Perevathan, where a mother provides financial support for her daughter's legal studies. Despite seriousness of the commitment, the court held that the agreement was non-binding because it was made within family relationship and relied on trust and goodwill rather than a legally enforceability. In conclusion, the agreement between Aida and her mother is properly characterized as a social and domestic agreement. There was no intention to create legal relation and therefore no valid contract was formed. As a result, Aida's mother is not legally obliged to continue paying the 2,000 ringgit monthly allowance. And that's all for me. Thank you.
Good day and Assalamualaikum. My name is Siti Amir binti Amir. My student ID is 253UU2550Q. I will be presenting issue number 4. But first, I will be reading the scenario first. The scenario is, after completing her studies, Aida joined the Ministry of Health under a 5-year government scholarship bond. 2 years later, she resigned to work overseas, and then the government demanded that she repay the entire bond amount. But Aida argued that the terms were unfair and constituted a penalty. The parties in this particular scenario is Aida, the scholarship recipient, and Ministry of Health or MOH, the scholarship provider. The issues in this particular scenario is whether the MOH can demand repayment of the entire amount of the scholarship from Aida after she resigned from her government job. 2 years into 5-year scholarship bond, despite Aida's argument that the clause is unfair and amounted to her to penalty. The laws that can be applied in this particular scenario is Section 5 of the Contracts Amendment Act 1976, remedy in the event of the breach. Section 5B1 stated that if no such sum is mentioned in the scholarship agreement, the scholar and the surety shall be jointly and severally liable to pay, and the appropriate authority shall be entitled to be paid. And the whole amount expended on by the appropriate authority under the agreement. Next, I will be explaining this particular section. As I said earlier, I will be explaining the section 5 and also how it is applied into the scenario. So, section 5 clearly stated that if the scholarship agreement does not state a specific amount of money to be paid when there is a breach, then both student, the scholar, and the guarantor surety are responsible. And they are jointly and severally liable, meaning that the authority can ask both of them together or either one of them alone to pay. What must be paid? The entire amount of money that the government or the authority had spent on the student under the scholarship. That's what actually under the section 5B1. So how it is applied? It is applied under Section 5B1. The MOH is entitled to recover the entire amount expended on her scholarship, regardless of whether an exact sum was mentioned in the agreement or not. And this reflects the statutory or the section capacity given to the government to enter into such scholarship contracts and recover costs without needing to prove loss or damages. That's how it is applied in this scenario. Next, another law that can be applied to the scenario is the case of University of Malaya and Lee Min Chong. Why I say it can be applied to the scenario? Because it mirrors the scenario. So, in the case of University of Malaya and Lee Min Chong 1986, the fact is Lee Min Chong, or also known as Lee, received a scholarship from the University of Malaya under the Colombo Plan to study in Canada. He agreed to serve the university for 5 years upon return. And failing which he would be liable to pay 5,000 ringgit. After only 2.5 years of service, after he returned from Canada, Lee resigned without the university's consent, and the university then sued Lee to recover 5,000 ringgit as per scholarship agreement. Lee argued that the agreement was void or had been fulfilled, and the court held in favor of the university. It held that the agreement was valid and enforceable, and Lee was liable to repay the 5,000 as agreed. After this, I will explain how it is applied in the scenario. Here, I will be explaining how the case is applied to the scenario of Aida. So, this scenario have the same facts, or it mirrors the fact as the case of University of Malaya and Lee Min Chong 1986. In that case, the court held that when a student accepts a scholarship and later breaches the bond terms, they are legally required to repay the full amount expended on them. The judge also clarified that such repayment was not a penalty, but instead it's a rather reasonable compensation for the breach of the contract, especially because the student had freely entered into the agreement. So, in this case, even if Aida argues that the repayment term is unfair, the law does not view it as a punishment. But instead, just like in the case of Lee Min Chong, the repayment clause exists to restore the government to its original position to not penalize the student. Since Aida broke the terms after only 2 years of service, she is legally liable to repay the full scholarship cost as stated as the agreement. So the conclusion of this scenario is MOH, or Ministry of Health, is within its legal rights to demand full repayment from Aida, and also as set out in Section 5 of the Contracts Amendment Act 1976, and the decision in Lee Min Chong reinforces that this type of repayment is enforceable and not a penalty.
Next, we move to the last issue of this question, which relates to acceptance of an offer. The situation is as follows. At the same time, Aida planned to purchase a house in Seremban from Laila, who is a property agent. Laila offered to sell the house for Rm 500,000 and Aida replied by offering for Rm 450 instead. Laila rejected this counter offer, and a few days later, Ida changed her mind and wrote back stating, I agreed to buy at Rm 500,000. However, Laila refused to sell on the ground that the offer was no longer valid. From this fact, we can see that Ayla is the offerer as she made the original offer to sell the house, while Ida is the offeree who is intended to purchase the property. Now, what is the main issue here? So the main issue is whether Ida's final message stating I agreed to buy at Rm 500,000 constitute a valid acceptance, even though she had earlier made a counter offer of Rm 450,000, and whether such counter offer prevents a subsequent acceptance of the original offer. Now we discuss what law or what section will apply to the situation. Under Section 7A of the Contract Act 1950, in order to convert a proposal into a promise, the acceptance must be absolute and unqualified. What is absolute and unqualified? This means that the acceptance must be matched exactly to the terms of the offer made by the offerer. The offeree must accept the offer without introducing any variation. If the acceptance is not absolute and unqualified, it does not amount to the acceptance. Instead, it may constitute a counter offer made by the offeree. Now, there is a question. If a counter offer happens, what legal effect it will carry? A counter offer will terminate and reject the original offer made by the offerer. Once the original offer is terminated, the offeree cannot revive it by simply later attempt to accept the original terms. Next, we move to the cases. For this issue, I applied two cases. The first is the hide and range. In the case, the defendant offered to sell his farm to the plaintiff for 1,000 euros, and the plaintiff then responded by offering a new price, which is 950 euros, and the defendant rejected his offer first, and after receiving the rejection, the plaintiff tried to accept back the defendant's original offer. The issue is whether a valid contract has been formed, but the court held that there is no valid contract existed because the plaintiff did not accept the offer absolutely and unconditionally. Another case that perfectly reflects this issue is the Malayan Flour Mills Berhad versus So Eng Chi. In the case, the defendant offered to sell lot 5020 to the plaintiff for Rm 350,000, and then the plaintiff proposed to buy the same lot together with three other lots for Rm 470,000, changing the both price and the subject matter. And this proposal was considered as a counter offer which diverted the offerer's mind from the original offer. As a result, the original offer was treated as withdrawn and it could not be longer be accepted. These both cases clearly explain the principle that an acceptance is not valid when a counter offer is made. Okay, now we apply the issue to the law. As I mentioned before, this scenario involves the application of Section 7A of the Contract Act, which requires that an acceptance must be absolute and unconditional in order to form a binding contract. The facts of this case closely resemble the principle established in the case of hide and range as well, where the court held that no contract existed because the original offer had been terminated by the counter offer and could not be revived by later acceptance. And similarly, in the present situation, Laila made an offer to sell the property to Ida for Rm 500,000, and Ida's initial response proposing for Rm 450,000 did not amount to a valid acceptance under Section 7 subsection A, as it was not absolute and unconditional. By proposing a different price, Ida made a counter offer which in law had the effect of rejecting and terminating the Laila's original offer. And once Laila rejected this counter offer, the original offer of Rm 500,000 ceased to exist. After this, when later Ida stated that she agreed to purchase the property at the original offer, there was no longer valid offer capable of acceptance, because at the stage Ida was making a new offer rather than accepting Laila's original offer, and this consistent with the reasoning in the hide and range case, where the original offer cannot be revived merely because Ida later changed her mind. And therefore, even if Ida argues that a later acceptance should be binding, the law does not recognize it as a valid acceptance under Section 7, subsection A. And accordingly, Laila's statement that the offer was no longer valid is legally correct, and she was entitled to refuse the Ida's subsequent attempt to accept. To summarize, there is no valid acceptance by Ida, so neither Ida nor Laila is legally bound. And this scenario shows that an acceptance must be absolute and unconditional. Any variation will terminate the original offer. And if a piece of advice that I can give to Ida and Laila, if Ida and Laila wish to enter into a contract now, Laila can make a new offer with a clear terms. For example, including or specifying the price and stating that no further negotiation on the price will be allowed, and the contract will only be binding if Ida accepts the new offer exactly as proposed. That's all from my team. Thank you for watching.